We're here with our buddy Jim Trusty, attorney extraordinaire. Jim, how are you, my friend?
Hey, I'm good. Thanks for having me on.
It's a pleasure. Just want to start this way, Jim. Have you ever seen so many of these trial judges, these lower court federal district, not national judges, issuing rulings in every aspect of executive branch ministerial tasks to try and stop this president?
No, I mean, the numbers are clear. The number of preliminary injunctions, which are normally kind of a rare creature, even in the abstract, before you start talking about the executive branch powers, the numbers are through the roof for President Trump compared to any other chief executive. And really what you have, this is just lawfare continued. We've been living this lawfare nightmare where phalanxes of lawyers wait in the bushes to attack everything that comes out of this White House. They're filing suits every day. They're picking their venues carefully. They're picking their judges as best they can. And they're landing in very favorable kind of echo chamber places where they can get judges to immediately sit for Saturday hearings and demand answers to questions they're not entitled to. And, it's putting a lot of pressure on the system when lawfare continues unabated.
And this is a very, very serious constitutional issue. We're not talking about a case here and there, a civil or criminal case where judges get things wrong. Chuck Schumer bragged on PBS, Jim Trusty, that they installed 235, his words, not mine, progressive judges to stop Trump should he get elected president. He's doing exactly what we're saying he's doing and these judges are doing. They're being cherry-picked by bringing cases in these districts where these judges exist. They're getting the results they want. The plaintiffs are. Many of them are Democrat politicians, attorneys general, union bosses, and the like. I think the American people are going to lose total faith in this process, don't you?
Yeah, you think about Justice Roberts having said recently that we shouldn't identify the parties to which judges belong. And I thought to myself, that's a wonderfully hopeful and naive thought. But the reality is, particularly across the Democratic appointed judges, they're as predictable as rain sometimes. And you see bold partisanship by district court judges who overstep their bounds, who just comfortably announce that they're going to take control of executive branch functions. I mean, you look at what's happening in D.C. with Judge Boasberg right now. His questions had nothing to do with legal authority or his ability to challenge an act within the Alien Enemies Act. His questions were setups for contempt. Why aren't you giving me factual details that I demand in this kind of shady hearing? Why are you not trusting me when I say submit something under seal? And they know on the government side there's a good chance that seal is going to last about a New York minute and lead to public disclosure. So, they're being told, if you're the government, you're being told, come respond to complicated issues by judges who don't seem to have any real set parameters to what they're going to inquire about. And then they're speeding and they're kind of racing through this system. And I think ultimately putting pressure on a Supreme Court that doesn't want to have to deal with these questions. I mean, that's really the message from Justice Roberts is don't make us the ones that are unpopular because we keep undoing politicized decisions. But short of Congress weighing in and changing a lot of laws, it's coming to the Supreme Court. And I think I heard somebody the other day say grow a pair, but that's kind of what has to happen with the Supreme Court. They have to realize they're going to be the arbiters of how much of this lawfare our country can tolerate.
And Jim Trusty, a couple of weeks ago, they could have killed this thing right in the crib. They had that case from the judge who was forcing the administration to spend $2 billion. I understand the technical aspects. Bills were, created and invoices. It doesn't matter. And not only that, you had the 4 conservative justices who were absolutely stunned and appalled. They're appalled at these national injunctions from these district courts, which has gotten completely out of hand. They're actually more powerful than the Supreme Court, if you think about it. One judge sits there and says, oh, you can do that. Oh, you can't do that. He's in San Francisco. He's in Seattle, Boston, Providence, Washington, D.C., the whole country. And you turn that plane around and you bring those Venezuelan gang members back, and you do it now. You do it by 5 p.m. I'm going, what the hell is this? And by the way, I litigated the case with Landmark Legal Foundation in 2003 in front of Judge Lamberth. It is the practice of that district in Washington, D.C., that these whether they're temporary restraining orders, whether they are injunctions, whether they're orders, period. They must be reduced to writing so the people who they're directed to have notice. When you are ordering an entire bureaucracy to do something, you can't just say something from the bench and expect to whisper down the lane that it's going to reach the target. The president's not sitting there. The attorney general's not sitting there. The secretary of DHS isn't sitting there. He blew it. So if he tries to hold them in contempt, Judge Lambert said, well, I can't because I didn't put it in writing. He's going to have a little bit of a problem, isn't he?
Yeah, well, the interesting thing, and you know this too, Mark, coming up with a written decision, a written ruling, is very different than a full written opinion. I mean, you would be okay on that front as a judge if you issued a minute order, they call, where you literally don't even issue a piece of paper. You get on the docket and you say, I'm ordering A, B, and C. You don't have to really give your full rationale to meet, kind of check that box.
Right.
So, you're right. But here's the thing. I mean, a little part of me thinks there's kind of an unintended consequence that could be brewing here. The facts of this particular case are really kind of the right kind of facts for the executive branch. I've got 261 murderers, rapists, killers from a gang that invaded this country during a 4-year period of an open border. So your starting facts are helpful. The thought that a district court judge should jump to the height that the ACLU and others make him jump by saying, let's have a hearing Saturday, let's ignore privileges that could apply to the government making this type of decision to coordinate with El Salvador, and then to perhaps fast forward into contempt, which seems to be where Boasberg is going. I in some ways, those are facts that set up a very nice platform for challenging these nationwide injunctions in a very sympathetic way. So if that were to make its way, I don't expect a lot of help from the circuit court. The D.C. Circuit Court of Appeals
bad court.
It's also kind of in the business of taking their time when the district court rushes. So they allow hearings to happen without acting as quickly as they could sometimes to stay the proceedings and start weighing in. So I think, again, this is what happens with Lawfare. They pick not just the district, but the circuit where they think they're going to be pretty good. Rhode Island, North California, Maryland, D.C., and you're kind of stuck bubbling up to the Supreme Court. But I think the facts of this particular one with Tren de Aragua, particularly if they did vet carefully and they can literally say all these people are horrible people, those are good facts for an opinion coming out of the Supreme Court someday.
I agree. But don't you also think, excuse me, the longer this goes on, it's going to be harder to have a rule or two to set down for these courts. In other words, you're getting these disparate opinions in every area that Trump is making decisions and so forth. So they can talk about in terms of national injunctions. Yes, I agree. But when it comes to the substance of this stuff, the longer this goes on, the tougher it's going to be for the Supreme Court to come up with the rules. Don't you think? I mean, they can do it maybe on the injunctions not being national in some form, but the diversity of these cases and so forth and so on, and the violation of separation of powers becomes more complicated. Wouldn't it have been better if John Roberts and Amy Coney Barrett have joined the other 4 justices? I'm sure William Rehnquist would have, and Scalia would have, and so forth, and put an end to this right away.
Yeah, I mean, you're right. There's a legal whack-a-mole going on here where the issues, I mean, the lawfare continues unabated. It's always hurried, emergency, injunctions, selective venues. But the actual underlying issues as they are can be radically different, right? It's a different issue about Congress having the power of the purse than there is the employment of the Alien Enemies Act. So there's always going to be some sort of different legal hook. And you're right. The more it's really only limited by the creativity of a bunch of attorneys who are at war with this president. So they're always going to come up with new stuff until there's some sort of comprehensive shutdown, of the attacks on the executive branch.
What do you make of Schumer on PBS the other day, simply saying, yes, there's a constitutional crisis. Yes, Trump is a dictator. Yes, this is why I got 235 progressive judges on the bench to stop him. Is that a confession?
Yeah, well, for some reason, Chuck Schumer seems to just kind of get away with whatever verbiage he wants. I mean, I still haven't gotten past the fact that he's threatened 2 sitting Supreme Court justices over Roe versus Wade. And then he's a leading voice about how, Trump's words instill violence in America. I mean, it's just, if hypocrisy was a crime, he would probably get executed for it. But, look, I think we all know elections have consequences, and that, that the chief executive is in a position to do a lot to stock the benches. And it's not just the Supreme Court. I mean, this is a great lesson for people outside of law or who don't obsess on legal process like we do, that, all of these district court judges, names across the country you've never heard of, those selections, those confirmation hearings are so important because there's so much mischief that can follow if they're not good balls and strikes umpires. And that's why, these confirmation hearings, I love seeing guys like John Kennedy, just different folks lighting in with like fundamental process constitutional questions. And more often than not, exposing those Chuck Schumer picks as being woefully uneducated and ignorant and really incapable of being judges. But it's the sausage factory. Some of these people are getting through. They get in positions where everything around them is an echo chamber of support. The kind of the social climate of Washington, D.C. for judges is very one-sided. And so if you're going out on a limb and firing off all sorts of interrogatories to the Department of Justice and announcing that you're going to stop planes in mid-flight, then you're going to get heralded as a hero, as somebody fighting for, quote, rule of law, when really you're degrading the rule of law.
Mm-hmm. All right, my friend. We very much appreciate you. Jim Trusty. Thank you, brother. God bless you.
You too, man. Good to talk to you.
You too. Have a good weekend. It's a good man, Jim. He's a very good friend.